Okay, so I'm just going to dive right in. We're going to start with some stuff with the district attorney office and some of the things that you said and what he said. So in a press release, you said, in my experience, some of Steuben County's district attorney office's indictments are determined to lack sufficient evidence to even be considered by a grand jury in the state. And at times, people within Steuben County are gravely overcharged. Do you have any examples of this happening?
Examples in terms of overcharging? Yes, so there was a case not too long ago that happened in the town of Corning where an individual was charged with attempted murder that ultimately shouldn't have been, in my opinion, shouldn't have been charged. While that case wasn't dismissed or downgraded by a court, it was through a plea offer. So there's one. In terms of other specific examples, I can't give you any over the course of my career in the past 10 years I've personally had 2 or 3, as well as being heavily active in the defense bar up there. I know that that is something that's discussed quite a bit.
Can you give me the names of those cases?
The name of what case?
The one that you mentioned about the one that you just mentioned, or any of them, so we can confirm that.
The one that I'm specifically referring to is the people of the state of New York versus Lori Simmons.
Okay. And why do you, so why do you think that the DA has potentially charged or overcharged your client?
Why do I think that in this specific case?
Yes.
Well, just looking at one of the charges, again, this is all, in my opinion, I haven't had a chance to sit down and read the grand jury minutes yet. The discovery in this case is voluminous. We're talking terabytes, not just gigabytes. So just in a brief glance overview of the charges, the criminal enterprise charge requires, just in general, 2 other felonies completed in furtherance of whatever criminal enterprise we're talking about. Both of the felonies that my client's charged with, both the falsifying a record, the thing with the power of attorney, and this falsification of a business record. I don't think in the falsification of a business record specifically, in my opinion, in my reading of the law, and again, this will be an argument that attorneys have forever, I don't think that that meets the definition of the crime. So if one of those 2 charges is dismissed or is found not guilty on or something like that, if we ever get to that stage, the criminal enterprise charge would go away.
Okay. When we read off some of that statement to Brooks Baker, the district attorney, his response to your statement was the idea that we routinely overcharge is simply fallacious and not supported by reality.
He's entitled to his opinion, as is everybody else. I can only talk about my experience in that
county. Is he claiming that this is a political or incompetence by, or are you claiming that this is a political or incompetence by the DA?
Political? I think there's definitely the potential for some political overtones. Incompetency? No. Most DA's offices try to obtain the highest charge they can. I mean, it just makes sense that they would do that. It doesn't mean there's anything nefarious going on. Of course, there could be in some cases, and I'm not saying that that's happening here, only because I don't know that yet. That could change based upon my review of all the testimony and phone calls and police reports and that kind of stuff.
So let's move on to the case itself. Do you intend to take this to trial?
If need be, yes.
Does your client, does Steve Maio plan on resigning in his position in the county?
That's something that we've been discussing quite regularly, and I can't take a firm position and wouldn't feel comfortable putting that on the record in any way.
Okay. In what part of this process would that be more, that decision be made more affirmed?
Are you asking what throughout the criminal case would help shore up that decision?
Yes.
That I can't answer. I just, and that's not because I'm trying to dodge the question, Ariel. It's only because I don't know. And just, again, not specific to this case, but in a general criminal case, so much can happen from now until whenever a jury trial is held or a motion argument is held. There's a lot of different things that can come up that would either improve a client's position or drastically decrease a client's position. So I would literally be taking a guess or throwing a dart at a dartboard to give you that answer.
Does your client feel that he can serve successfully with these charges hanging over his head?
Yes.
It hasn't been distracting at all, or
Again,
getting any pushback from the county or the people?
That I don't know, only because I'm not heavily involved in that arena. In terms of distraction, yes, of course, anybody charged with a crime like this that's, highly publicized, of course it's going to be distracting to some extent, but we're all professionals and we know how to push that stuff to the back of our minds and continue to plug away.
And he's still practicing law as well, correct?
To the best of my knowledge, yes.
Does your client know the other people that are charged in this, especially the family or with the history of murder?
No, but by other people, we got to break that down. There's 4 co-defendants. So are you asking specifically about the co-defendants, or are you asking about the other people tangentially involved or who would have testified?
Both. Let's start with the co-defendant.
So he does know Mr. Comfort Sr. In terms of the other people, no, he doesn't really know them.
In what extent does he know him?
Mr. Comfort Sr., he represented him on buying a parcel of property and did an eviction for him at one point. I mean, nothing substantial.
Is that how he's connected with these other folks in this case?
When you say connected, I don't, are you asking if he was friends with this gentleman outside of, no, I don't believe so. I think he just did some work for him.
So does your client deny a relationship with the others, or just no criminal conduct with them or anything?
He doesn't really know the other people involved. So we would we would put on the record that we would deny any relationship with them because we don't know them. And we would deny, of course, any criminal wrongdoing.
It's just so curious that he's lumped in with all of this and not really knowing them at all.
Well, and from my understanding is that's the way with a couple of the other individuals. I guess at the arraignment, from what I've heard, again, I don't know this for a fact, but from what I've heard at the arraignment, a lot of the other individuals were looking around, asking who everybody else was. And again, not specific to this case, but basically this is essentially a RICO or a criminal racketeering case. It's called a criminal enterprise in New York State. Not everybody's going to be associated with one another. Not everybody might know one another. So yes, it does lead to some questioning of, well, if they're not overly involved, why are they charged? And that's exactly my thought in this case in particular.
Does your client have a message to the public? And if so, what would that be?
I didn't discuss that with him particular. So, I mean, I would feel uncomfortable speaking on his behalf to the public only because I haven't had that conversation with him.
How is he handling all this and as well as his family?
It's difficult. I mean, no matter, and this is the sad part just about the criminal justice system in general, no matter how this plays out, okay, even if he's found not guilty after a trial, you can't take this down from the internet. You can't take away the fact that he was charged. Even if he's found not guilty, nobody's ever going to apologize to him. So it's difficult. It's having a monstrous effect on his life.
Yeah, I can only imagine. Can you break down exactly what he is being charged with and how he's connected with all this? Because there's some pretty extreme charges.
Yes. So the indictment itself is, I think, 34 or 35 counts in total. My client's name is only tied to 3 counts. One count is the overall criminal enterprise count. The second count is forgery, which is reference to some power of attorney that my client allegedly made, notarized, I believe, a state power of attorney form for somebody else. And the third charge is falsification of a business record that relates to I believe, a state police officer typing up a police report that they're alleging contained false information. Those are the only 3 charges. I mean, Attorney Baker himself said he's not involved. He wasn't even charged with any of the quote unquote sex trafficking crimes, no crimes involving any children. I think there was an endangering charge in one of the counts. That has nothing to do with my client, as well as there's possession or criminal sale of drugs, controlled substances. And again, there's nothing in the indictment that ties any of that back to my client.
Let's break down these charges a little bit. Let's start with the first one you were mentioning, the criminal enterprise. Thank you. What does that mean, and how are they claiming he's involved?
How much time do you have?
How much time do you have?
The criminal enterprise charge, and again, this is just in general stuff, okay? And this shouldn't be taken as legal advice. This is just my own opinion from 10 years of doing criminal defense work. The criminal enterprise charge itself charges a larger act or people acting in concert of conducting an overall criminal enterprise. So the criminal enterprise charge is basically an actor or a criminal defendant taking 2 or more acts in furtherance of a larger criminal enterprise or a conspiracy to do that. So the law, there's different subdivisions for that charge, okay, that say you can charge somebody in different ways. The one particular to my client in this case, again, as I said, is committing 2 other acts which rise to the level of a felony that further a criminal enterprise. So that's the specific charge to him. The falsifying business record, this forgery with a power of attorney, were both done in furtherance of this larger criminal enterprise. So the theory, I believe that the theory of the people would be, based upon those 2 things, he furthered the criminal enterprise, which would make him just as guilty if he was partaking in the criminal enterprise, because he kind of didn't. I'm not saying he did, right? But if those charges are proven, they were done in furtherance of the criminal enterprise, which would make him part of the criminal enterprise. We deny on those charges, and I, again, don't think that one of them at least doesn't legally fit. But that's the essence of that criminal enterprise charge.
Okay, let's go down next to the forgery. How is this involved in this larger picture?
That I can't answer at this time. I truly don't know. I'm assuming it's a power of attorney form. There's going to be something where somebody got money in some way, shape, or form, but I without reviewing all the discovery and getting a bill of particulars from the people, I don't know at this point.
And then you kind of touched on the falsification of the business record and lump that in with a state police officer. Can you elaborate on that a little bit more, please?
So the falsification of a business record charge, again, just in a general, not tied specifically to this case sense, talks about, and if you bear with me, I can pull it up so I can.
That's fine. Take your time.
Okay, so the falsifying of a business record charge is basically the statute words it as with the intent to defraud, a person makes or causes a false entry to be made in a business record of an enterprise. And with the intent to defraud, it includes an intent to commit another crime or aid or conceal the commission of another crime. So in this, there's a bunch of legal definitions that come into play. One, what's an enterprise? Two, what's a business record? And three, what's a false entry, or how do you make or cause a false entry? I believe that my client is charged with this from, and this is just from reading the indictment, he met with a state police entity, an enterprise, and something then happens based upon that conversation with these people, something that they're deeming a business record, I'd assume a police narrative, is then entered into, is made, and they're alleging that it contains some sort of false statement or lie or something in it.
So they're saying that he lied in some kind of statement.
No.
Or no?
He never gave a formal statement. He lied. Well, I believe, and again, this is just, I haven't had it. I don't think I've been provided yet this actual statement, although I did get a box of stuff today. I think what they're saying is he spoke to an officer wrote something down, and they're saying that what the officer wrote is a lie. But he's not charged with lying under oath or giving false testimony or perjury, nothing like that.
So I'm no expert in the law, but if it was the officer that would have lied, why is Steve Maio being charged with this?
My question, exactly.
You said you just got a box of information right now. How much information are you getting? Because some of the stuff I understand that you cannot answer because of client or attorney privilege, but some of the stuff seems like you don't know.
So we got to remember where we are in this case. We're in the infancy. And while the discovery rules have changed, there are exceptions, okay? So with the new discovery rules, all discovery is supposed to be turned over to a criminal defense attorney within 15 days. That's if it's possible. In conversations with Attorney Baker, this was a year-long, potentially 18-month investigation. We're talking a long, long process. So I can only imagine that there's volumes upon volumes of not only paper, but electronic files. If there's recorded conversations, those are, lengthy. And that's going to generate, I think in one conversation, there was a reference to a terabyte, which is my understanding of computer stuff is limited, but I think a terabyte is 100 gigabytes. I mean, that's huge. So we're really working the process of exchanging material, because the defense, we have that same obligation. We've really been put into contact with one another so far to facilitate that and as fast as possible. And everybody involved understands. I mean, just to copy that material from one hard drive to another would, I assume, take hours. So we're working on getting all that done now.
So you just mentioned that's what you're getting done now. So what are the next steps?
So the next steps are to see what materials turned over from the prosecution, review it, as well as I'm still old school in a lot of ways. I was trained a certain way. I conduct my own investigation. By that, I mean, I talk to people, I knock on doors, call people. I'm very interactive in every case that I handle. So that's the next step for us. Once we get that done, we then engage in motion practice, and then we have hearings if needed, and then prepare to go forward.
Is Steve Maio looking at possibly being disbarred?
If there's a conviction for a felony, yes. As I said, to my knowledge, they haven't taken any temporary action. We haven't been notified yet. I'm surely hoping that they don't, because like I said, he's innocent. But that's something that we'd have to take up with the appellate division and the ethics committee.
If he is found guilty, what time is he looking at potentially for these charges?
I don't know that, and I only don't know that because I haven't looked it up myself. They're all felony counts, so if he's convicted of even one, there is a potential for state prison. The top count's a B felony, meaning it's probably violent, even though there's no violence alleged. The law classifies certain crimes as violent. B felonies typically have a violent classification. I don't know if this one specifically is violent or not, but I mean, years, to put it bluntly.
And I was talking to DA Brooks Baker, and he's saying this is going to be a lengthy process.
Yes.
We're looking at maybe years going through all of this. Would you confirm that as well?
Years?
Or
I surely hope
before going to the court.
It's kind of beyond everybody's control. Right now with the pandemic, we're getting new directives weekly from courts. I mean, we just were notified not a couple of weeks ago that all bench trials have had to stop in criminal courts. So while we're in a hurry to get this done, we might not be able to. I mean, just because of the pandemic, we're at the mercy of scheduling from people from the Office of Court Administration and appellate divisions, and that might be beyond our control.
This is a pretty intense case, and obviously with somebody who's in this position with the county and also a local attorney, it's obviously got the attention of a lot of people. Have you personally worked on a case with this much attention or at this scale?
Yes, I've handled murders, attempted murders, negligent homicides. Yes.
Does this one make it any different because of it being, a legislator, county legislator?
Different in terms of what?
I don't know, your experience having to communicate with the press more, or any kind of public backlash, any more attention?
Maybe a little bit more attention, which I'm not necessarily opposed to or a big fan of. I carry a philosophy just from growing up and how I was trained to let my talking occur in a courtroom. That's where it all matters anyway, so that's where it should all be held. In terms of, does it change how I handle a case? Absolutely not. And if you talk to any client that I've ever represented, whether it's back from my time as an assistant public advocate, where I did a lot of assigned work in my own private practice, or even retained clients, I treat everybody with dignity and respect. Every case is a high priority to me, and every case gets my full attention. I routinely work way too much. You can ask my wife; she would concur with that statement. And her biggest complaint, as well as my office staff's, is I'm way too accessible to clients. So it doesn't change my practice or philosophy and how to practice in a case, no.
And then just kind of circling back to Steve Maio, I believe you mentioned this in your previous release, but just to reiterate, does he stand by that he is not guilty on all charges?
Yes.
How does he feel, or what is his reaction have been with you going through this process?
Emotional. I mean, this, like I described before, he holds a heavy heart for the allegations lodged against him, and he knows that they're untrue.
Is there anything that I didn't ask that you'd like to share?
If we could go back to the district attorney's comments, he stated in when you spoke with him, he said that it might be based on not knowing how grand juries work. I do know how grand juries work. Anybody who's paid attention to anything that's happened in this country in the past year and a half understands how much power an attorney, no matter who that attorney is, and this isn't directed at Mr. Baker at all, district attorneys in general in a completely secret proceeding hold a lot of power. And you can look at any other case, national, not national, that's occurred in the past year to show how much power that attorney in that room holds. They make decisions such as what charges are recommended, how those charges are read and instructed to a grand juror, what evidence is presented, what evidence isn't presented, who testifies and what questions are asked. And again, this isn't directed at District Attorney Baker in any way, shape, or form, but to address his comment about a lack of knowledge and how these charges are the grand jury's charge and not the people's. While the grand jury voted to indict him, they only heard what the district attorney wanted them to hear. And that's not specific to this case. That's on every case. If a criminal defendant knows of a grand jury being convened to testify or give his side of the story, he's got to file a letter in writing and jump through some hoops. And that's how our law works, right or wrong. Some people disagree with it, others don't. But that, I mean, to say that my comments show how a grand jury doesn't work, I don't think that's a fair assessment of why I said what I said. In fact, I think it would be the opposite.
Would Steve Maio like to have an opportunity to share his side?
Oh yeah, and we'll have that. I mean, right now there is no side. He doesn't know where these charges came from. I mean, if I'll leave it at that.
Okay, sounds good. All right, well, thank you so much for taking the time. I appreciate it. And we'll be in touch.
All right, thank you.
All right, have a good day.
You too. Bye.
Bye-bye.